Welcome. I'm Pat Hines, and I'm the president of this wonderful association, and I'm so pleased to welcome you tonight on this very, very special occasion. It's really a stellar night for us. You can see the crowd that has turned out, and we were commenting, Justice, on the age group here. You have so many young women who have come to see you tonight, and mothers and daughters. It's just fabulous. And I'm so pleased that we have the opportunity to welcome all of you. This is now the 7th annual Justice Ruth Bader Ginsburg Distinguished Lecture on Women and the Law. And I would like to take this opportunity to thank our distinguished lecturer, Linda Greenhouse. It is indeed an honor to have her here this evening, and I look forward, as I know all of you do, to hearing from her shortly. The association established this lecture in Justice Ginsburg's name to celebrate her groundbreaking contributions to the advancement of women's rights and her achievements as a lawyer, law professor, and judge, and I might add, and a mother. And a grandmother, even better. And I would like to thank Justice Ginsburg for agreeing to allow us to create this distinguished lectureship in her name. We like to think of Justice Ginsburg as one of our own treasures, as she served on this Bar Association's executive committee from 1974 to 1978. Justice Ginsburg, we appreciate your continued close involvement with the lecture, and we are honored by your presence here tonight. But I am fond of saying that Justice Ginsburg is with us every night because I love to look up at her portrait. She is very good company for me in this room, and I really feel very good and encouraged when I look up and see her with all the guys. So, Justice Ginsburg, you are always with us, and we are so pleased that you are here not only in your portrait, but in present here tonight. The City Bar has worked hard to help eliminate gender bias in our laws, our courts, and in our profession. In our efforts, we are building on the foundation of great pioneers, such as Justice Ginsburg, without whose groundbreaking contributions to the advancement of women's rights and her achievements as a lawyer, professor, and judge, we would not be where we are today. Justice Ginsburg has long been a strong voice for justice, gender equity, civil rights, and working to eliminate gender bias in our laws and in our courts. After graduating Phi Beta Kappa from Cornell University, she attended Harvard Law School, where she was only one of 9 women in a class of in 1959, before graduating then from Columbia Law School. After facing, we have the contingent here tonight. After facing difficulty finding a job upon law school graduation, in 1963, she became only the 2nd woman to join the faculty at Rutgers University School of Law. And we have that contingent here tonight, I know. Later at Columbia Law School, she became the first tenured woman on the faculty. While at Columbia, she founded the Women's Rights Project of the ACLU. And that contingent is here. As director of the Women's Rights Project, Justice Ginsburg argued cases, many before the U.S. Supreme Court, which challenged sexual stereotypes and paved the way for new and better opportunities for women. It is my distinct pleasure to invite Justice Ginsburg to the podium.
when the city bar, some months ago, asked what I thought of inviting Linda Greenhouse to deliver tonight's lecture, my reaction was immediate. Don't let the day go by before calling her. For Linda's reporting about the court has been wise, witty, clairvoyant, and to borrow another French expression, très sympathique. She knows that the justices need observers and reporters to keep us alert to our human fallibility. But she also knows the court's prominent role in our U.S. system of government, and she regularly demonstrates that knowledge in her caring and respect for the court as an institution greater by far than the sum of the individual members at any given time. In a 1996 Yale Law Journal article telling the court's story, Linda described the challenge of working on a beat where no one holds press conferences and confidentiality is vigilantly guarded. The press corps, she wrote, is often groping alone in the dark, trying to make sense of the shadows on the cave wall. As a regular reader of Linda's articles, I have seen over a span of some 3 decades, not shadows, but light, constantly cast on the court's actions and decisions. She explained what we did and said in plain English, thus rendering our dispositions accessible to the interested public. She managed to condense and convey our opinions without skipping over the rough spots. She noticed the nuances and offered the reader not spins, but accurate, honest counts. It takes a bright mind and prodigious preparation to report as she did. Among accolades Linda has received, one of the best known came from my D.C. Circuit colleague, Lawrence H. Silberman. In a 1992 talk to the Federalist Society, Judge Silberman deplored the tendency of certain judges to drift to the left to gain favorable press comment on their jurisprudential growth. Silverman reported that some court watchers called this dangerous tendency the greenhouse effect. While I cannot say that any of my colleagues wrote with Linda's approval in mind, sadly, I have no doubt about the large influence her reporting has had on the quality of press accounts about the court and its work. In 1998, Linda Greenhouse was awarded the Pulitzer Prize for beat reporting. It was an honor well earned by our top translator and commenter. Linda has received many other high honors from the long list. I will mention only one. In 2002, Anthony Lewis and Linda Greenhouse were selected by the American Law Institute for the Henry J. Friendly Medal, awarded for outstanding contributions to the law. Linda and Tony remain to this day, if I have it right, the only non-lawyers granted honorary membership in the ALI. Linda was the first print reporter to gain access to Justice Harry Blackmun's voluminous papers housed in the Library of Congress. She said of her first exposure to the 500,000 documents filling 600 feet of shelf space that she found herself standing in front of a huge open-faced mine on which seams of precious metals were visible running in various directions. Her goal was to work the mind, to locate the most promising seams, and see where they led. The result, a masterpiece produced in 2005 titled Becoming Justice Blackmun. The book tells of the odyssey of a man once called Minnesota Twin to his friend from days when they were very young, Chief Justice Warren E. Burger. One main theme of the book is the disintegration of the Burger-Blackmun friendship. Another, the impact of the cases that troop before the court on the mind and heart of Justice Blackmun. Garrison Keillor, who knew and admired the justice, called the book an elegant biography. Tony Lewis called it a thrilling book. Harvard Law School professor Lawrence Tribe described it as a jewel fully worthy of Linda's reputation as the best journalist ever to have covered the work of the court. All who have read the book, I think, would concur in those judgments. Linda is about to start her life's next chapter as Knight Distinguished Journalist in Residence and Joseph M. Goldstein Senior Fellow at Yale Law School. She will teach, help to launch Yale's Law and Media program, serve as advisor to a Supreme Court litigation clinic, and engage in scholarly pursuits from which I am confident people in diverse disciplines will benefit. So, with appreciation for the work she has done to date and great expectations for the productions still to come, I invite all of you to join me in welcoming Linda Greenhouse to the podium.
Justice Ginsburg, thank you very much for those words, and you're a very busy person, and you put in much too much work in pulling that together. Just trying to get this microphone to behave. Is this okay? Yeah. So as you can imagine, it's a thrill for me to be here, and a thrill to be introduced to you by Ruth Ginsburg. Looking at these portraits, I'm reminded that just a few days ago, she and I were at a dinner together at the Union League Club in Philadelphia. So just imagine a dining room with a ceiling higher than this and portraits, I'd say 4 times the quantity of these, every one of which a white male. And not only Ruth Ginsburg, but a number of women I know in this room have been responsible for making that scene the anachronism that it was. So I applaud all of you who've devoted your lives and careers to that end. Which gets me to my talk. Almost 25 years ago, the great Shirley Abramson, currently Chief Justice of Wisconsin, offered some reflections on the day in August 1976 when the governor of Wisconsin named her to the state Supreme Court. With her appointment, she not only became the first woman to serve on Wisconsin's highest court, that was a distinction that went without saying in 1976, she became the only woman to sit as a judge at that time anywhere in the state. There were 2 women who were no longer sitting who had preceded her in the state system. And just as a frame of reference, at the time of her appointment, only 8 women had ever sat on a federal Article III court anywhere in the country. In her brief memoir, later published under the title, The Woman Has Robes, Justice Abramson recalled the question she was asked at the press conference that, to her considerable surprise, she found herself conducting that summer morning in 1976. These were the questions that she got. 1, were you appointed because you are a woman? 2, were you appointed to be a token woman on the bench? 3, do you view yourself as representing women in the courts? And 4, do you think women judges will make a difference? Well, those in the audience who are or have been judges may well have been asked one or more of these questions themselves. If you were, you probably gave answers similar to those that Shirley Abramson gave, at least to the first three. Having graduated first in her law school class, she replied that her appointment was obviously based on merit, that she was, quote, not a token anything, and that she planned to represent, quote, all the people of the state of Wisconsin, just as she assumed that the male members of the judiciary did. The fourth question was and remains the tricky one. Do women judges make a difference? Quote, I always take a deep breath when I hear this question or one of its variants, Justice Abramson said, and here's what she explained. Quote, the questioner usually has a stock list of the wonderful qualities he or she associates with women. Now I'm trapped. Naturally, I want to have all these wonderful traits attributed to me, but do I believe that? I've spent a lifetime fighting society's urge to stereotype both men and women, so what am I to do now? What she did tell her questioners was that she would necessarily bring to the bench all her life experiences, including growing up as the child of hard-working immigrants who had little formal education, of having practiced and taught tax and business law, of marriage and parenthood, and yes, of being female. That meant, she said, that she was at once an insider and an outsider, someone who had worked with success inside the system, but who at the same time had demonstrated throughout her life a willingness to act contrary to the expectations of others. All these experiences and qualities would contribute to the kind of judge she would be. Well, we live today, of course, in a much different world, which this room is testimony to. Shirley Abramson was, in fact, the only woman in her law school class at Indiana University. Today, as you all know, women make up about half the class in most law schools. 19 of the 50 state court chief justices are women. Actually, 19 and a half if you count Texas, which has a bifurcated appellate court system for civil and criminal cases. And Sharon Keller is the presiding judge of the Texas Court of Criminal Appeals. And the list of states where women sit as the head of the court system includes some states that are not necessarily known for their position at the cutting edge of social progress: Alabama, Georgia, Missouri, North Carolina, South Carolina, Tennessee, Utah, just to name some of them. In state court systems as a whole, women make up 26% of the judiciary. They are 29% of the judges on the state courts with final appellate jurisdiction. There are 167 women currently serving as active federal district court judges, 1/4 of the total. Women hold 29% of the currently filled active positions on the federal appellate circuit courts. And with women now constituting about 1/3 of all lawyers in the country, these statistics are really not very far off the mark. Of course, the outlier to this progress is the United States Supreme Court, but we won't go there. Nevertheless, it's no longer the slightest bit unusual to walk into a courtroom anywhere in the United States and find a woman on the bench. But still, the question of whether it makes a difference remains a delicate one all these years after Shirley Abramson held her press conference, and for the very reasons that she explained. We cringe from the stereotype thinking suggested by the question. Justice Sandra Day O'Connor had her own favorite answer. At the end of the day, a wise old man and a wise old woman are going to reach the same decision, she said many times. And yet, how many of us, when we read a retrogressive opinion on reproductive rights, written by a judge for whom pregnancy was never even a theoretical possibility, mutter through gritted teeth, no woman would have come out with that? There's been a lively academic interest in the question of whether female judges make a difference, but for years the results of the research were equivocal due to poor data and faulty models. A recent, as yet unpublished study, which earlier this year won a prestigious award for the best paper presented at the annual meeting of the Midwest Political Science Association, makes a persuasive and nuanced case that in one area of the law, sex discrimination, the presence of a female judge does make a difference. While there's no discernible difference in other areas of the law, women rule in favor of a sex discrimination claimant significantly more often than male judges do, and male judges themselves become more favorably inclined towards sex discrimination claimants when sitting on appellate panels with at least one woman. I won't go into the further details of this study because the precise data don't really matter for the larger point I wish to make, and neither do the data themselves provide an explanation for why the presence of a female judge should matter to the outcome of sex discrimination cases. In fact, the data raise more questions than they answer. Are the male judges who become more open to sex discrimination claims when serving with a female colleague just being polite or politically correct? That hardly seems likely given what we know of male judicial personalities. Can it be that they actually learn something from the women? And what about the women themselves? It hardly takes a lot of fancy numbers crunching to suppose that women's life experience may have something to do with the outcome of these cases. These are questions in need of further study. I, for one, would be interested to know whether the study's retrospective conclusions will apply prospectively. Will younger women on the bench, who are part of a larger cohort and may well not see themselves as barrier-breaking pioneers, continue to display the same sensitivity to sex discrimination cases? Well, rather than attempting to answer these questions, which I couldn't do in any event, I'd like to use them to frame a larger question. How do judges know what they know, or what they think they know, about discrimination or about anything else? This question is especially pertinent at the appellate level, where when it comes to the facts on which to base a legal conclusion, judges generally are bound by the factual findings below unless they can demonstrate that those findings are clearly erroneous. They're largely captives of the information presented to them by the parties and the amici. There was a dramatic example at the Supreme Court this past summer of the limits of appellate judges' knowledge. As you may remember, the court ruled at the end of its last term that the death penalty is an unconstitutional punishment for the crime of raping a child. Justice Kennedy's opinion for the 5-4 majority relied in considerable part on the conclusion that there was a general consensus in the country against punishing this particular crime by death, and that capital punishment for the rape of a child was therefore cruel and unusual within the meaning of the Eighth Amendment. Justice Kennedy noted that only 6 states made child rape a capital offense, and he also observed that while Congress expanded the reach of the federal death penalty during the mid-1990s, child rape was not included among the new capital crimes. There was just one problem. Congress, in fact, had acted in 2006 to make child rape subject to the death penalty under the Uniform Code of Military Justice. True, this new provision applied only to crimes committed by military service members, and its relevance to the court's Eighth Amendment jurisprudence was far from obvious. But what was obvious was that the majority's assertion that there was no federal law on the books that made the rape of a child a capital offense was simply not true. This case, Kennedy against Louisiana, was one of the more high-profile cases on the Supreme Court's docket during its last term. Yet no one, not the parties, not their amici, not the federal government itself, had thought to bring this recent legislation to the justices' attention. The government, in fact, filed no brief in the case, a clear sign that the Solicitor General saw no federal interest at stake. Obviously, no one involved in this case at any level was even aware of the new law. It came to light only as the result of the post on a blog devoted to military law, written by a civilian specialist in the military death penalty 3 days after the court's ruling. Well, there followed a flurry of activity as both the state of Louisiana and the United States Solicitor General filed briefs asking the court to reconsider its decision. Ultimately, that request was denied and the decision was reaffirmed. Here surely is an instance when judges did not know what they thought they knew. It might be tempting to assume that judges would be on safer ground if only they could watch a video and see for themselves what really happened in a case that they're reviewing. Factual ambiguities would be dispelled and judges would know what they needed to know. But not quite so fast. A Supreme Court case from 2 terms ago illustrates the weaknesses of that assumption. The question in Scott against Harris was whether police officers acted reasonably in chasing and forcing a speeding driver off the road. The driver, a teenager who was not suspected of any offense other than driving dangerously, was rendered a quadriplegic by the ensuing accident and sued the police officers for violating his right to due process. A video camera mounted on the dashboard of the chase car recorded the chase. The justices watched the video and then posted it on the court's website as part of the majority opinion, which concluded that the fleeing driver was so obviously a menace to public safety that no reasonable juror would have quarreled with the officer's decision to use deadly force to take him out. And indeed, the video did show a scary drive at breakneck speed on a dark and winding country road. But the vote in Scott against Harris was not unanimous. It was 8-1. The dissenter was Justice John Paul Stevens. Certainly Justice Stevens is a reasonable man, or at least as reasonable as his Supreme Court colleagues. He had, in fact, learned to drive many years ago on dark and winding roads, and he did not view the driver's behavior as justifying deadly force. His own life experience, in other words, determined his view of the facts of this case. Professor Dan Kahan of Yale Law School was sufficiently intrigued by this case to conduct a social science experiment. He showed the tape to a sample of 1,350 people and studied their reactions. Well, it turned out that most people thought the Supreme Court was correct. Not everyone did. And the demographic portrait of the two groups proved to be quite distinct. Those who agreed with the court were most likely to be white, male, and from the South or West. Those who disagreed, those who agreed with Justice Stevens, were more likely to be non-white, female, and from the Northeast. In other words, responses to the video on which the court based its conclusion turned out to be, at least to some measurable degree, culturally determined. So who is the reasonable juror or the reasonable justice? How do judges know what they know? In April of last year, the Supreme Court upheld the Federal Partial Birth Abortion Ban Act of 2003, as I'm sure you all recall. This decision, Gonzalez against Carhart, was based on a remarkable collection of premises indulged in by the 5-4 majority and by the author of the majority opinion, Justice Kennedy. One premise was that while any abortion is the occasion for sorrow and regret, quote, it is self-evident that a woman whose doctor performs her abortion by the method that the statute criminalizes, quote, must struggle with grief more anguished and sorrow more profound, unquote, when she realizes what has happened. What's quite amazing here, and I won't even try to top the eloquence of Justice Ginsburg's dissenting opinion, is not only the patronizing assumption that reduces a woman to seeking to terminate a pregnancy to a childlike state of ignorance, but also that Justice Kennedy offered no citation, no factual backup for his assertion about what goes on in a woman's heart and head. It's simply self-evident. He and the others in the majority buy into the myth of the existence of a post-abortion syndrome that has been abundantly discredited in the psychological literature, as described in briefs presented to the court by medical organizations as long ago as 1989. An editorial in the Medical Journal of Obstetrics and Gynecology criticized Justice Kennedy for, quote, his rejection of evidence-based practice by failing to include a single medical reference in support of his opinion, unquote. How do judges know what they know? The Supreme Court's abundant encounters with the subject of abortion actually offers a more heartening example of the trajectory of judicial knowledge. The year after Justice O'Connor arrived at the court was faced with deciding the constitutionality of restrictions on access to abortion that had been adopted by the city of Akron, Ohio. The majority declared these restrictions unconstitutional on the basis of Roe against Wade, which had been decided just 10 years earlier. Justice O'Connor, confronting her first abortion case on the Supreme Court, dissented in an opinion that was a broadside attack on Roe itself, noting that premature infants were being saved at younger and younger gestational ages. Quote, it is certainly reasonable to believe that fetal viability in the first trimester of pregnancy may be possible in the not-too-distant future, Justice O'Connor said. She continued, the Roe framework then is clearly on a collision course with itself as the point of viability is moved further back toward conception, unquote. Well, whatever one thought about Roe against Wade as law, Justice O'Connor's reasonable belief was simply incorrect as a matter of obstetrics and neonatology. There is no prospect of fetal viability moving back into the first trimester. The medical community made it its business to inform Justice O'Connor of this fact 6 years later in a subsequent case in which the court's continued adherence to Roe against Wade appeared to be directly at issue. In this case, Webster against Reproductive Health Services, the American Medical Association, the American Academy of Pediatrics, and other medical organizations filed a brief explaining what they called the anatomic threshold that makes survival before about 23, 24 weeks of pregnancy impossible, even with mechanically assisted respiration, due to the incapacity of fetal lungs. Quote, improvements are not expected in the foreseeable future, the brief concluded. Neither in Webster nor in any subsequent opinion did Justice O'Connor ever refer to this brief. But she never mentioned the so-called collision course of Roe v. Wade again. And as everybody in this room knows, she came to play a key role in preserving the constitutional right to abortion. So a good judge is not necessarily one who starts out knowing everything, but one who's willing to learn. Which brings us back to the question of sex discrimination. One of the most notable, indeed notorious, decisions of a rather notorious Supreme Court term, October term 2006, was the Title VII pay discrimination case of Lilly Ledbetter against the Goodyear Tire and Rubber Company. I'm sure you know this case well. Lilly Ledbetter, the underpaid manufacturing plant supervisor, whose Title VII claim was foreclosed by the Supreme Court's interpretation of what constitutes an act of discrimination, has become a symbol of the Roberts Court's parsimonious attitude toward access to court for citizens other than corporations. As you recall from her appearance at the Democratic National Convention, she has carried that role, that undesired role, with grace. Just to refresh your recollection of the facts of this case of statutory interpretation. The question was how to apply Title VII's 180-day statute of limitations in the context of a claim of pay discrimination. Was the discriminatory act, the unlawful employment practice, the initial pay-setting decision, or was it the issuance of each subsequent paycheck that reflected, and more to the point, perpetuated the initial discrimination? The Equal Employment Opportunity Commission's longstanding paycheck accrual rule embodied the latter definition, but this policy was repudiated in the Supreme Court by the Bush administration, which entered the case on behalf of the employer. The employer won by a vote of 5-4. The court held that Ms. Ledbetter's claim was time-barred because she should have filed her charge not during the year she left the company, which is when she learned that her monthly pay was as much as 40% lower than that of the men she worked with, but many years earlier when her pay and that of her male co-workers began to diverge. She was, by the way, the only woman of her rank at the plant. Well, my purpose is not to rehash the arguments in this case. The next Congress will have an opportunity to fix this problem in the Fair Pay, Lilly Ledbetter Fair Pay Act. Rather, my point is to examine this decision through the lens that I've been using to look at some other recent cases. What do judges know? Well, as manifested by Justice Samuel Alito's majority opinion, they don't appear to know much about the workplace, or at least the private sector. I don't believe that Justice Alito has ever cashed a paycheck in his adult life that was not issued by the federal government. Federal employees, whether Justice Department lawyers, federal prosecutors, or judges, and he's worked as all three, are paid according to published schedules. There may well be secrets in the federal workplace, but who gets paid what is not among them. The private sector, of course, is very different. Many of us in this room, myself included, could tell stories of learning only long after the fact of pay disparities that defied any benign explanation. In any event, Justice Alito's majority opinion began by asserting that Ms. Ledbetter's case was governed by, quote, established precedent in a slightly different context, unquote. The established precedent holds that the 180-degree charging period runs from any, quote, discrete act of discrimination, such as termination, failure to promote, denial of transfer, or refusal to hire, unquote. All the majority did was to add a pay-setting decision to this list. That was the slightly different context. Basically, that was the end of the case from the majority's point of view. But as Justice Ginsburg's dissenting opinion pointed out, the, quote, realities of the workplace showed that the majority had made a category error. Pay discrimination did not occur in a slightly different context. It was completely different. from the public, or at least the immediately ascertainable events of termination, failure to promote, refusal to hire, and so on. Justice Ginsburg wrote, compensation disparities, in contrast, are often hidden from sight. She noted that this very employer kept salaries confidential, as do some 90% of all private employers. And she observed that if a female employee receives periodic raises, as Lily Ledbetter did, she might well assume that she's moving up along with others, despite the fact that without her knowledge, a disparity that initially might have been too small to complain about is growing with each passing year, since the percentage increase is calculated on a smaller base. The majority's failure to understand this reality, Justice Ginsburg said, meant that the court, quote, has strayed from interpretation of Title VII with fidelity to the Act's core purpose, unquote. So how do judges know what they know and recognize what they still need to learn? As we move forward into a time of challenge and change for our courts, we can only hope for judges, women and men, with the wisdom and humility to know the difference. Thank you very much. I'm happy to take questions.
Are there questions? Right here.
What do you think of the prospect for Eric Holder as Attorney General?
What do I think of you mean whether I think he'll be confirmed or whether I think he'll be a good Attorney General? It's above my pay grade, but, I mean, I have a high regard for Eric Holder, but let's be honest, anything would be an improvement, so. See, I'm liberated. I'm no longer, a daily journalist. I can tell you what I really think.
This is your chance. Yes, you can hear from.
What is the law and media project going to do? Because it occurs to me that any of us in this room would like to see a vast improvement in the way the media cover rape cases. And maybe you'd like to help.
Could people hear that question? I don't really know how to answer that because I'm not actually running the Law and Media project at Yale, which has a big grant from the Knight Foundation and is trying to find its identity there. Whether it's going to focus on how rape cases are covered in the U.S. media, I kind of doubt, but I'm happy to put that in the hopper. Just go back there. You want to go to the mic? I can't hear you, so why don't you go to the mic? Well, I'm not going to be reporting, as such. I do have a kind of an open invitation from the op-ed page at the Times to weigh in or at least send in my thoughts when the spirit moves me. They haven't promised to print, whatever I said. But, as the court term goes on, I do have some thoughts that I'll put on paper, but I'm not going to be, reporting as a regular matter.
As an observer of the court, did you notice any change in
Did I notice any change in Justice Kennedy?
It just seemed that he was more aware, more in tune with the rights of individuals.
Well, the Kennedy opinion that I thought was extremely telling in the Roberts regime was his separate opinion in the parents involved case, the Louisville and Seattle school integration cases. That was a remarkable display on the part of the plurality in that case. Just to refresh your recollection, the question in that case was whether it was constitutional for the formerly de jure segregated school system of Louisville, Kentucky, and the longtime de facto segregated system of Seattle to take very modest measures in terms of student assignment at the margins to preserve the very hard-won gains of integration. in their public schools. And it was remarkable that the court granted these two cases in the absence of a circuit conflict. They had denied an earlier case when Justice O'Connor was still on the court, but the minute she left, they granted these cases. And in a plurality opinion by Chief Justice Roberts, the court declared these two plans unconstitutional. John Roberts, a summa graduate in history from Harvard, said that Louisville, Kentucky had no compelling interest in attempting to preserve integration into schools because it had been released 7 years earlier from federal court supervision. Rather ahistorical analysis, in my opinion. But to the point of my answer to your question is that Anthony Kennedy, who, to my knowledge, although there's someone in this room who has a better database and maybe can refute me, had never voted in his entire Supreme Court career to uphold any government policy that counted by race, wrote separately and said, I cannot sign this opinion. I cannot sign an opinion that says there's no compelling interest for Louisville, Kentucky to maintain integration in its public schools. Of course there's a compelling interest. Now, he agreed the plan was unconstitutional because he said it wasn't sufficiently narrowly tailored to survive that second prong of equal protection analysis. But, you know, that the performance of Chief Justice, I still haven't gotten over the performance of Chief Justice Roberts in that opinion that in terms of judicial leadership or lack thereof, that he was willing, he was so dug in his extreme position that he wasn't willing to move to get Justice Kennedy and to write an opinion for the court. I thought was very, very telling. And, you know, whether that experience opened Justice Kennedy's eyes for, you know, future cases, it'll be really interesting because he does, you know, currently is right at the balance, the tipping point of the court. And, you know, whether he reads the news zeitgeist that was manifest in this month's election and responds to it in some other way. It's one of the really interesting questions going forward at the court right now, I think. Someone was standing, I think, at the mic. Did you
want to have a question?
Am I able to convey a voice to you? Yeah. All right. The question is like, we all read in the New York Times recently the issue of...
I'm having a little trouble hearing you.
It's not conveying... Am I not loud enough?
Speak up.
Oh, well, that won't happen. But I would just say that in the New York Times recently, we all read about how the importance of the return to the rule of law and how hard that will be, difficulty from the Department of Justice on down and the Supreme Court and et cetera. And I was just very interested in your views about that struggle. We can talk here about the city bar, which has been very involved and importantly in looking at candidates for judicial appointments as well as Supreme Court appointments, and very proud of that record. And now, as we move into a different period of transition and change, I was just wanting to compliment you for holding this lecture. And I also, you know, am interested that the city bar stay vigilant in looking at everything that goes on the judicial appointment agenda. Thank you.
Is that a question? Oh, okay. Thank you.
How many Supreme Court appointments do you think that President Obama will get to make in his first term? And who should he be appointing?
I knew someone was going to ask me the first of your questions, and I don't have the foggiest idea.
Yeah, but what's your best guess?
I don't make guesses about that. I mean, really, I'm amazed at the, you know, all the people pontificating about this, and the answer is nobody knows, and the current incumbents don't know either. I can assert that to you from my personal knowledge. So I wouldn't stand up here and even, you know, all I know is that the 9 people currently on the court will someday not be on the court, but in what order, and, you know, I have no idea. Who should President Obama appoint? Obviously, we need more women on the court. I would hope, and I'm hardly the only one who's advising him of this, I mean, I'm not advising him by talking this, that he would look outside the current resume, which we are in a historically unique situation where all 9 of the incumbents had as their immediate past job service on a federal court of appeals. I mean, that's never happened before in the history of the country. So, you know, I think one among the many reasons Sandra O'Connor is missed on the court is that she brought to the court, you know, a kind of a non-doctrinaire sense of reality growing out of her service in politics. She had run for office. She was the first woman to ever be majority leader of a state senate, which she was in Arizona and so on. So, you know, I think there's a number of very well qualified female governors who had been their state attorneys general. There are, you know, I mentioned 19 out of 50 of the state high courts have female chief justices. There's lots of people out there from state systems or from non-judicial backgrounds at all. I mean, it's only recently that we've come to this notion that you have to have served as a judge to be on the Supreme Court. Earl Warren was never a judge. He was governor of California for 3 terms. He ran on the National Republican ticket as vice president. Lewis Powell was never a judge. William Rehnquist was never a judge. So there's, you know, other kinds of biographies that I think ought to be in the mix when we think about the future of the court.
Speaking of other sorts of biographies, you are, I'm sure, aware that the Constitution does not require that the Supreme Court justice be a lawyer. As a non-lawyer who has learned to be protected of the legal community.
If nominated, I will not serve. I've read too many cert petitions already.
That wasn't my question.
Okay.
Actually, I think it's a great idea. Sorry to take that. My question is, what do you think of the idea of a non-lawyer?
I think it's a terrible idea. I mean, no, I think it's a really bad idea. For one thing, you know, I mean, for all kinds of reasons, which everybody in this room can think of, but the reason I would cite is you want somebody who can play in that sandbox and hold their own, you know, at conference. And you know, of course there's a learning curve to climb for anybody who goes on the Supreme Court, but you want it to be climbable. So no, that's a non-starter of an idea, but thanks for mentioning it.
Yes, down on the front.
You're moving into the world of academia, and you are going to be working with law students and other folks. What are your goals? What do you think are the most important issues you want law students to be thinking about?
Well, this is going to sound very narrow-minded and selfish, Kathy. You know, I just want to have a fun second act. I mean, seriously. I was a daily journalist for 40 years. That's a lot of daily journalism. And, you know, Yale Law School was not holding its breath for me to come along and bring, you know, enlightenment. They have, like, a really fabulous curriculum and faculty and even better students. So, you know, I want the chance to do in the daylight what I've been doing a little bit obsessively for the last few years, nights and weekends, which is writing law review articles and, you know, thinking deeper and digging deeper into various issues that I couldn't treat to my own satisfaction as, you know, 900 or 1,100 word pieces in the paper. So it's I'm very selfish and, you know, got this great opportunity and I've taken it and you know, I want to be, you know, I hope I can sort of play as a peer with a fabulous group of people.
Going back to your thesis
I can't hear you, sorry.
Going back to your thesis of what judges know and how they know it, to what extent or to how much influence do judicial clerks have on helping judges know what they know?
Well, I'm probably not the best person in this room to answer that question. You know, I think there's a few answers to it. Certainly, you know, ideally there's sources of new current thinking coming out of the legal academy. You know, they've all been law review editors and very smart and plugged in, and it's a, you know, source of intellectual refreshment that constantly goes on in chambers. But I've never been one who believed that the clerks were much of a substantive influence on the output of at least the Supreme Court. You know, I remember every summer in the cafeteria when I would see the new clerks, you know, coming in, and, you know, I knew they were, you know, working their way through the pile of cert petitions to write their first pool memos, and, you know, coming to it from a standing start. I would think, you know, I could help these people if they only, you know. So I mean, I just have never had a very clerk-centric view of the function of the Supreme Court.
Over there.
Yeah, I just want to know, in your years of in court, what was the one question you always want to ask?
Well, she only wrote one opinion that I really disagreed with. And I forget the name of the case. She may remember it. It was a forfeiture case, right? And it was, the question was it a violation of, was it a due process? Come on. Come up and defend yourself.
Linda, stop me if I have the wrong case, but it was the city of Detroit had a real problem with prostitution. So it decided that instead of taking the women and locking them up, it would go after the men. And it said, if we catch you in a car with a woman, you walk. The car is forfeit. Well, in this particular case, the car was co-owned by the wife of the man who was made to walk. And she complained that the state couldn't forfeit a car that belonged to her. Now, I will just say, read my opinion. But I will tell you the follow-up to that. In the fullness of time, I received a letter, and it said, there you go again with your inappropriate language. In the Bennis opinion, you used the word John. Now, I'm sure if prostitutes were called Ruth, you would not have used your name that way. And then he said, please respect those of us named John. And Linda, I was for a moment saying, how insensitive could I have been? Because the author of the majority opinion, of the dissenting opinion, I wrote the majority. The author of the dissenting opinion was none other than John Paul Stevens. So
the bottom line, you rejected the wife's claim.
Yes, yeah. We said that if Detroit has that solution to the problem, then it shouldn't matter if the car is co-owned by a best friend, anyone else. That the city was entitled to have that policy and say the car goes, and that was that.
Pretty tough. Should we take a vote?
No, I'd rather take Lily Ledbetter's case to a vote, because I think it would be unanimous in my favor. I needed only one more.
Maybe people have questions for you. You're standing here. What's the one question you all wanted to ask her?
In answer, I would like to answer one of the questions, although my spouse put me down and said, don't do that. This question about, well, are you going to predict who will leave the court next? Well, I'm very sensitive on that issue because I am the second oldest judge on the court at the moment. So if you count down, it's John Paul Stevens is 88, I'm 75, and then the rest, the newest justices are still in their 50s and not likely to leave anytime soon. Now, I have said again and again that I will hold my office as long as I am capable of good behavior. That means doing the work. But there are still those who don't believe me when I...
Justice Ginsburg, I wonder what decision you were in the minority that you were the most distressed, or you were the most, that you most regretted the way the majority ruled?
Well, I regret many of the decisions of the majority, most recently in the environmental protection case for marine mammals. But I suppose if I had to pick just one case, it would be the question whether a child born of unwed parents abroad can gain citizenship automatically because of her relationship with her father. The law has very few explicit gender lines left, but that's one that it does. That a child born of an unwed pair can automatically acquire the citizenship of the mother, but not the father. The court divided 5-4. The majority opinion was written by my very dear colleague, John Paul Stevens. And I thought, well, perhaps it's a generational difference. But you know, I truly like and know that I must work with 8 other colleagues. And it doesn't do to get angry or remain angry, because you want to go on to the next case, and maybe you will capture the mind and the vote of your colleague who just wrote what you thought was a dreadful opinion of the court. I mean, collegiality really does matter in our workplace. I don't think the court could function as it does if we didn't genuinely respect each other.
How about the particular saying
Bush v. Gore was an endurance contest because the court decided to hear the case on a Saturday. Briefs were filed on Sunday. The argument was Monday. The decisions were out. The opinions, I should say. It was only one decision. Were out on Tuesday. And most of us had been up literally around the clock. It wasn't. We weren't sure what line the majority opinion was going to take. Things kept changing. Of course, I was extremely disappointed. I considered my approach to that case entirely restrained, the way a non-activist judge should be. That is, I thought the court should stay out of it, that the Constitution provided a mechanism for determining who would be president, and it made the tribunal, not the Supreme Court, but Congress. So I thought we should have stayed out of it. But yet, we had a January sitting coming fast upon us, and we had to work together on those cases. And we met a few days later to talk about the January sitting. Things were almost the same. Bush v. Gore was something that happened, and then it was over. And it has not been cited. I think I'm right about that, Linda. The court has never cited Bush v. Gore in any later case, and I expect it will remain that way. By the way, I don't think that the Supreme Court decided the election, because I think it would have come out the same way in the House, given the composition, the Republican majority at that time. We just made it happen a little sooner.
Hi. Sorry. I'm curious to hear your opinions on DOMA, and will the court ever take cert in your DOMA case, Defense of Marriage Act?
Well, the court, as you know, is a totally reactive institution. We don't decide, well, this year we want to solve, say, expert testimony in civil cases. So we respond to what's out there, and the cases have to start in the lower courts and travel their way up to us. And even if there is an interesting question, we generally don't take the first case to reach a judgment. We wait to see how other courts will respond to it, and we will get in there when other courts disagree about the answer to it. So first you have to have the plaintiffs who will bring the action and pursue it in the lower courts. But the court is just not made to be an initiating institution. It is there was a fine judge on the Fifth Circuit, Judge Goldberg, who once said that the federal courts do not make the fires with which they deal, but do their best to put them out. So in that sense, we are like firefighters.
Thank you very much. This has been an extraordinary... Thank you all very much. And I think this will really go down in the books. This has been a great event. Thank you.